What is ADR? Mediation and Arbitration for Property Managers. Have you ever wondered how property managers handle disputes without heading to court? The answer lies in alternative dispute resolution, commonly known as ADR. This approach provides practical methods for resolving conflicts involving tenants, landlords, and contractors without the hassle of traditional litigation. Let's break down how mediation and arbitration work and why they are essential tools for property managers. First up is mediation. In this process, a neutral third party, the mediator, steps in to facilitate communication between the disputing parties. The mediator's role is not to make decisions but to guide the conversation, helping both sides reach a mutually acceptable agreement. Mediation is voluntary and confidential, making it a quicker and less expensive option than going to court. One of the best parts about mediation is that it tends to preserve relationships. This is especially important in landlord-tenant situations where ongoing interactions are common. Property managers can use mediation to resolve issues related to rent, repairs, or lease terms. By addressing these disputes early, they often prevent them from escalating into bigger problems. Now, let's talk about arbitration. This method involves a neutral arbitrator who listens to both sides of the dispute and then makes a binding decision. Think of it as a private judge. While arbitration is more formal than mediation, it is still generally faster and less costly than traditional court proceedings. Arbitration can be either voluntary or required by specific clauses in leases or property agreements. Once the arbitrator makes a decision, it is usually final and enforceable, providing clarity when parties need a definitive resolution. Property managers often turn to arbitration for more complex disputes or when mediation does not lead to an agreement. So, why should property managers consider using ADR? First, it helps resolve disputes efficiently, saving time and money. Second, it supports positive tenant relations by offering less confrontational ways to resolve conflicts. Including ADR clauses in leases can ensure that mediation or arbitration is the first step before any legal action, helping to manage disputes proactively. Moreover, being familiar with ADR processes allows property managers to guide tenants and landlords smoothly through conflict resolution. This knowledge can protect them from legal risks and minimize downtime caused by unresolved issues. In summary, understanding alternative dispute resolution through mediation and arbitration equips property managers with practical tools to handle disputes effectively. By maintaining good tenant relations and reducing legal costs, property managers can excel in their roles and create a more harmonious living environment for everyone involved.